Thank you everyone for still being around here this afternoon, and thank you for the invitation to speak today. I'd like to start by, taking you back a decade. What were you doing 10 years ago now? Like 10 years ago today, say February 2005. I know what I was doing. I was a very junior academic living in a Melbourne share house with an academic chemist and an airline engineer who was still enjoying the fruits of his Ansett redundancy pay. That's going back, isn't it? John Howard was Prime Minister. Kim Beazley was the leader of the ALP after all of the fun and games of Mark Latham the year before and his manly handshakes. In 2005, you may well have been rather sick of The Prayer. That's the debut single of recent Australian Idol runner-up Anthony Kalia. You might also have recently seen $1 Million Baby. So this is sort of trying to culturally situate you back in 2005. And just one point, I was wondering, is my presentation going to come up or should I just pretend I don't have one? Which I just failed to do, didn't I? Oh, is that what I do? I didn't realise I had responsibilities here. There you go. And that's just to remind you of some of the joys of 2005. And to situate you technologically, in 2005 you were not using a MacBook Air like mine because they didn't launch until 2008. If you were social networking, you might have been using MySpace, unless you were a very early adopter of Facebook. You weren't using YouTube. Actually, according to something I read yesterday, YouTube's 10th birthday is tomorrow. And you weren't tweeting because Twitter didn't exist. So why the reminiscing? Well, I'm trying to emphasise the point that 2005 is actually quite a long time ago now. And why is 2005 important? Because that's when we should have got general safe harbours for providers of services online in our copyright law. So safe harbours provide shelter from damages and other monetary awards for people who host copyright material, who have caches for material, who provide search services or internet access. Shelter is provided for infringements done either by their users or done by the intermediary because it's essential to their operations, which are themselves essential to the functioning of internet infrastructure. And in return, the intermediary must meet certain requirements to cooperate in enforcement, for example, by having a system for notification of infringement and removal. Now, 2005 is important because, of course, 2005 is when the Australia-US Free Trade Agreement came into force, having been signed the year before. And under that agreement, we were required to provide safe harbours to protect internet access providers, people who cache, web hosts and search engines. So these being entities that were seen as providing basic infrastructure of the internet. And similar, though not identical, safe harbours exist in many of our trading partners, including the US, EU, Canada, and many others. Now that's what should have happened in early 2005. We should have moved into harmony with these other jurisdictions. Unfortunately, the drafters of the US Free Trade Agreement Implementation Act made a mistake. Instead of providing safe harbours to all online service providers, as required by the treaty, the Act gave those online service provider safe harbours only to carriage service providers. And I could get really boring and legal here, but basically that's telecommunications companies. So instead of safe harbours, as envisaged under the agreement, we got very anaemic, stunted safe harbours that give special treatment to some commercial entities, that is, carriage service providers, over other commercial entities who happen to be providing, for example, exactly the same service. Thank you. So let's be crystal clear about this, because there's been some recent debate about the point. Australian copyright law that provides no safe harbours for online intermediaries beyond carriage service providers was a drafting error that happened back in 2004, and it puts us in clear breach of the Australia-US Free Trade Agreement. And as authority for that proposition, I refer to myself, but also some of the world's most eminent scholars of international copyright law. So Professor Sam Ricketson and Professor Jane Ginsberg, who literally wrote the book on the Berne Convention, have pointed out the inconsistency in writing in a peer-reviewed journal and said that the law needs review and expansion. Now, some of you may not be familiar with Sam Ricketson and Jane Ginsberg, but that's almost like having God coming down from the mountain and telling you the Ten Commandments were real. I mean, they are leading authorities in this space. So we're in breach. We're in breach of the Australia-US Free Trade Agreement and have been for a decade. Of course, I understand you're all deeply shocked that Australia would not be complying with all of its international legal obligations. And how did that happen? Well, just to take you back a little further, 2004 was an election year. 2004 was a mad, panicked rush to draft and pass implementing legislation for a 1,200-page free trade agreement in sufficient time for an election in October 2004. Mistakes happened. And this wasn't the only one, but mistakes happened. But if it's a mistake, why haven't we fixed it? Well, we've actually got really close a few times. So there was a 2005 discussion paper that looked at maybe fixing the problem. There was the 2009 Digital Economy Future Directions paper, also talked about expanding the safe harbours. There was a 2011 discussion paper, and of course then last year we have the 2013 online infringement discussion paper. So we've come close a bunch of times. In relation to that online infringement discussion paper, that looked like our best chance recently to actually get a change. You probably remember this. We had the discussion paper released in July of last year. We had submissions due around September. It looked at a number of things, including expanding authorisation liability, website blocking, and expanding the safe harbours. On 10 December, in response to all of the submissions, most of which were fairly negative, there was a press release from Attorney General's Department and the Department of Communications that announced that industry would be required to develop a code to address peer-to-peer file sharing, that failing the code being agreed within 120 days, it would be prescribed, and that the Copyright Act would be amended to provide for website blocking. Buried down in the frequently asked questions of the associated with the press release is the text that I've got up there, which is why haven't you, because there was no mention of the extended safe harbours there. And you can see there, I mean, I don't need to read it out, but basically the government took the view that this was related to broader issues than just online copyright, and the proposal would not be pursued at this time, which is a bizarre statement, because these are safe harbours that are in the Copyright Act to protect from copyright infringement only. So how it's related to anything other than copyright, I'm not entirely sure. At least, so as far as we know, at the moment, safe harbours are off the table. And, I mean, you have to ask yourself, if this was a mistake, if this is clearly in breach of the Free Trade Agreement, what is going on and why is this so hard? Why haven't we had amendment already? And as it turns out, it's hard for all kinds of reasons that shouldn't make it hard. By the way, has anyone ever worked out what that button does? I want one of those buttons on my computer just to see what it does. The first reason it seems to be hard to do something about the safe harbours is every time you talk about the safe harbours, it brings up the issue of piracy and mass infringement, particularly peer-to-peer file sharing. And so the argument is put that, and we saw this in submissions last year, that the safe harbours that were meant to encourage cooperation with copyright owners haven't done so in the ISP context. Infringement hasn't been reduced. That shows the safe harbours don't work and they shouldn't be extended until they work. So until we see some more cooperation or more reduction in infringement. The irony of this would be funny if it weren't so frustrating. It's frustrating because the safe harbours were never designed to deal with file sharing. And they never included the kind of cooperation that copyright owners now want to address file sharing. And that's because the safe harbours we have were based on US law that was written into law in the US in 1998. Now, Napster was invented in 1998. So that was the first, mainstream file sharing. So this law simply didn't anticipate addressing file sharing. So frankly, the decision whether to extend safe harbours to online service providers generally has nothing to do with file sharing. Any failure or perceived failure of the safe harbours in that context is completely irrelevant because the safe harbours were never designed to deal with that problem. Another argument that we see for doing nothing about the safe harbours is that there's not a problem. There's no real legal threat for online intermediaries, hosts, search engines. None of them have been sued. In Australia, we haven't seen massive actions against YouTube or anyone else. Therefore, there is no problem. Of course, that's just wrong. There is a problem, which the ADA and many others have been raising for a decade, repeatedly. The schools, for example, were sufficiently concerned about caching, they got their own additional provision in the Copyright Act, which should never have been necessary. And in any event, an argument that until some host or search engine actually gets sued in Australia, we should leave the law as it is ridiculous. Because it's really an argument that it's okay to hold the vague threat of liability over people's heads indefinitely. And that's not the rule of law that I know and love. Another point to make here is that the legal environment has changed and is changing in recent times in ways that make the safe harbours, if anything, more important. I used to take some consolation from the fact that the requirements for avoiding liability under the safe harbours, so the cooperative things you're meant to do to help enforce copyright, notice and takedown, for example, were also the same sorts of things you'd do to avoid authorisation liability in copyright. So you could reduce your risk of liability just by complying with the rules. So they sort of covered each other off. But the safe harbours have always had another role, which is to reduce the risk of liability for direct infringement. And that role has become more important since 2012 and the decision of the full federal court in Optus TV Now, which had a very broad reading of direct liability and has increased the risk, legal risk, for a whole range of intermediaries in a way that can only be addressed via the safe harbours. So really, when copyright owners say there's no problem here, so we don't need to do anything, what they're really saying is there's no problem for them. Because under the current arrangements, they kind of get best of both worlds. They can get cooperation they want from the safe harbours without actually having to worry about the exemption from liability. And everyone else gets legal uncertainty. Another thing that is often said is that, another feeling that you get in the debate is that there's a concern that the safe harbours are about giving a free ride to organisations like YouTube at the expense of copyright owners. Now, anyone who thinks that that's right, that there's some sort of free ride, that the safe harbours create some kind of carte blanche, get out of jail free card that will be used by wrongdoers, has not been paying attention. Firstly, Australian courts have shown themselves quite willing to police the conditions of the safe harbours. One of the less frequently noted aspects of the reasoning of the full federal court in IINet was its discussion of the safe harbours, and in particular, the court's willingness to pass judgment on the reasonableness of IINet's policies for dealing with infringers. The full federal court dismissed the safe harbour argument of IINet, not because there was no policy, but because the policy that IINet said it had was not good enough in the eyes of the court. Now, I happen to think that's a bit misguided, legally speaking, but it should give copyright owners significant comfort. Second, courts in both the US and Europe have denied safe harbour protection in a whole range of cases. And thirdly, basically, anyone who thinks that YouTube or any of the big players is getting a free ride on copyright issues is kidding themselves. Intermediaries may not do everything copyright owners want, but the significant ones are not doing nothing, and they have not confined action to reactive notice and takedown. Another reason that this is not about a free ride for internet behemoths is that the largest players will probably survive without Australian safe harbours. And they can survive for three reasons. One, they have systems in place for remuneration, for takedown, etc. Secondly, they have the resources to devote to litigation or developing filtering technology, or both. And thirdly, they're based overseas, so they can make strategic decisions about where to site equipment and operations. So in thinking about the safe harbours, we really need to think past or around the behemoths. And we need to think about who really has a problem if we don't extend the safe harbours, and that's Australians. Specifically two key groups. One is a lot of the groups in the room here today. Libraries, galleries, archives, educational institutions, public sector institutions who must punctiliously comply with the law of the land and make material available online in accordance with their mission. And the second group is innovators. The new services, new platforms, new sites that want to innovate and do so in an open, legitimate, legally compliant kind of way. The thing is, if you put brakes on those innovators, you're really entrenching the existing big players. And here's where the question of Australia's national interest comes in. The new entrants can come in, innovation can occur, but it can't happen in Australia, right? Because you go overseas. So this is the issue. Oh, sorry about the presentation of that. This is the safe harbours issue for dummies, or the simple version. And I did have a much cooler font for this slide, can I just say, much closer to those books. But here's the problem. The absence of safe harbours in Australia puts us in breach of the Australia-US Free Trade Agreement, makes life difficult for public sector institutions, advantages entrenched players, hampers technology competition, drives innovation overseas, and for all that brings no genuine upside for copyright owners because the infringement will still happen, if it's happening. So that's our policy. Time to fix it, right? Time to enact some safe harbours. But wait, I hear you say, surely the safe harbours are out of date. They were written in 1998. They don't reflect today's technology or what can be done to inhibit infringement. It's not 2000. The reason for the safe harbours was to ensure the growth of this new thing called the internet. We don't have that problem anymore. The internet's everywhere. And thirdly, surely the safe harbours are unclear as presently drafted. We know there has been significant litigation around some of the safe harbours in the US and in the EU, around concepts like what's the level of knowledge of infringement you have to have in order to lose protection. And there's truth to all of those issues. There's truth to all of those points. That doesn't mean we don't do anything. Firstly, we can't do nothing because, again, we're in breach of the Australia-US Free Trade Agreement. We have to have some safe harbours. So we need to do something, and because I'm in Canberra, I'm going to use some poly speak, we need to have a mature debate about how to extend the safe harbours, okay? But, big but, the instinct will be to legislate and to find all those areas of uncertainty in the safe harbours and legislate about them. So the instinct will be to define, elaborate. And I'd just like to say, God, no. Please, no. In my worst nightmares, I see phrases in media releases like new and improved safe harbours, or perhaps gold standard safe harbours. Look, I'm open to other thoughts, but my instinct is leave the language as general as possible. If we try to define the necessary state of knowledge, we try to improve or legislate the hell out of these things, the potential for cross-contamination of other parts of the Act is significant, and the potential for more red tape and bureaucracy is also significant. So I'd say leave the detail out, and we need to think about mechanisms for developing more certainty around the safe harbours outside of the legislative process, whether through peak bodies. Perhaps the libraries can develop their own set of best practices, educational institutions theirs. But that's the kind of discussion we should be having, and not the pointless, legally incorrect arguments about whether we should extend the safe harbours, because that's just not up for debate. Thank you.